Welcome back to Estate Planning 101. I'm attorney Thomas Burton, and today's topic is 3 things a will can do. And by a will, I'm referring to a last will and testament used in estate planning. I'm attorney Thomas Burton. I'm an estate planning and asset protection attorney here in Wisconsin, and in my Estate Planning 101 series, I aim to educate and inform about the role of different estate planning documents and estate planning terms in the estate planning process. So today we're going to focus on what you can do with a will or a last will and testament. Now, I know people have heard of the word a will and they've been told it's important to create a will, but sometimes it can be unclear the reasons why. So today here's my top 3 reasons why you should consider making a will for your estate. And the first reason to make a will or create a will, and by making a will we mean create a will. In Wisconsin it must be a written will, typed document, sign it in front of 2 witnesses to have a valid will in Wisconsin. But the first reason to create a will is you can name your own personal representative. So in Wisconsin, you may have heard the term executor or executrix. In Wisconsin, the probate code, which is the law governing how wills and probate go in Wisconsin, calls this person a personal representative. So other states, and historically it was called an executor, but if you hear us talk about personal representative in Wisconsin, that's the same person. And that's the person named in the will to follow your wishes after you're gone. They, under the law, are required to present the will and file it with the probate court upon your death. Because remember, during life, a will is private. Whatever you put in it is your business and you can change it at any time. But after death, right here, it becomes public. You must file the will with the probate court, generally in the county where you reside at death. So this person is very important. They're in charge of administering the estate after you're gone, the personal representative. And when you make your own will, you get to choose your personal representative, who you want in charge. You nominate someone to the court, and generally we suggest you name at least 1 individual and a backup in case something happens to them. So they would be nominated in the will, and that's a great reason to make the will. Otherwise the court would have to appoint someone. They have to choose, and if there's competing people who want to be the personal representative, they have to choose among those people. We always advocate you making that choice because you likely know who's best at administering your estate. Now, second major reason to create a will is you can name a guardian for minor children. So this doesn't apply to everyone if you're children. If you don't have children or you have adults over the age 18, but for a lot of people, when they're making their first estate plan, they may have young children, and this is a big reason why. In the will, they can nominate a guardian who would be the legal guardian for any child under age 18 if they die. And in the case of a married couple, you often want this in place in case both spouses should pass away. Then there's someone named to take care of your children until they reach the age of majority. In Wisconsin, that is age 18. So key reason for anyone with minor children to make a will is you can also name a guardian. Not only the person in charge of the assets of the estate, but someone, the guardian, who would actually raise the children and be their legal guardian after you're gone, because a minor child cannot enter into legal contract. They're not an adult, so they need a legal guardian until they reach age 18. So that's the second major reason I see and often hear about for making a will, and this is something you can do inside the will, and the will can do for you. So without the will, you can't name your own personal representative. You leave it up to the court. Without that, you can't, you don't nominate a guardian. Again, it would be up to the judge to decide. Likely, if you have family, someone would petition for guardianship, but then the judge would have to decide between the family members who's best suited to raise the child. So if you know who you want to raise the child, aren't you in a better position to nominate this person? In my opinion, yes, the parents. So you can name one guardian, and then you can also name a backup. And again, if you are married, this is in the event both spouses are gone. If you're unmarried, it's especially important, because if you're gone and there is no other spouse, or the other parent is predeceased, that child would definitely need a guardian named if you're gone. So that's the other thing a will can do for you. The second thing, you can name a guardian for minor children. And now we get to the third thing, which is choose your own heirs. There's many things a will can do for you, but to me these are the three big ones why a will could be useful and why people should consider having one. So you get to choose who receives your property, your stuff, after you're gone. Any assets you own that are probate assets that would fall under the will, they are going to pass according to the terms of the will after you're gone. So common examples are real estate, financial accounts held in individual name, personal property, automobiles. If you don't have a plan set up where that asset bypasses probate, such as through a trust or a beneficiary designation, then it's going to go through the will. And if you make your own will, you get to choose the heirs, the people who would actually get the assets. If you don't make a will, then the state of Wisconsin has chosen your heirs for you in the Wisconsin statutes, the statutes on intestacy. And intestacy is what we call if you die without a will. You died intestate is the term you may see. And it's a very kind of confusing sounding terms, but it means if you die intestate, it means you have no will. So then, with no will, we fall back on the Wisconsin statutes. And the statutes generally say, now they go to a large degree depending on who your nearest living relative is. But generally, they go to the next of kin, if you've heard that term. Historically, in the Westerns and stuff, you'd hear next of kin. So that's how your assets pass if you don't make a will. So if you're married, and no children, to the spouse. If you have children, it may go to the spouse and the children. If you have no children and no spouse, it goes up to your parents and then out to your siblings, and it continues like that to the nearest, closest living relative. So if you want to not have a will in place, I suggest you definitely read those statutes and make sure that the nearest living relative is who you would want to receive your assets. Now, for some people, I say this may work out just fine. Let's say you have one child and they're the nearest living relative. It would get to them through the statutes of intestacy. If, however, that child's gone, then it might go to a relative you weren't planning on, let's say. Or maybe someone who doesn't need the money, or someone you don't even like. And finally, if you have no living relatives at all, some people have heard that your money goes to the government. And that is true, and I looked it up. It actually goes to the Wisconsin School Fund by statute. If there's no living relatives at all, that's the ultimate beneficiary. But first we go through the relatives. Now, that can work well, like I said, but most people want to choose their heirs. And a lot of people want to say, let's say, I want it to go to my kids, but if I don't have kids, or my kids predeceased, do I want it to go to my sister, or my brother, or my cousin? The answer may be yes, it may be no. But by making a will, you could also designate after my kids, or if I have no kids, then I want it to go to charity or something like that. Also, if you make your own will, you can leave a gift to charity up here, let's say $5,000 to your favorite charity, and then the rest split between my kids or something like that. So the statutes don't allow any of this. They're just going to get it to your next living relative. So if you want to choose your heirs and decide who gets what amount and when and how much, a will is a great way to do that. So sometimes at my office we talk a lot about planning and probate avoidance and planning to avoid probate through a trust. And as part of that, I've told people a will does not avoid probate, and that is the reality. A will is designed to go through the probate court process. As we say here, private, after death it becomes public, must file it with the probate court. So a will is not going to avoid probate for you, but there's still very important things a will can do for you and reasons to put a will in place. And these are some of the top 3 reasons in my mind why you would want to consider putting a will in place. 1, name a personal representative, basically name someone in charge of your estate after you're gone. 2, name a guardian for minor children, again choosing who you want to raise the children after you're gone. And 3, choose your own heirs. You get to choose versus the state of Wisconsin, the default statutory interpretation scheme. So you can notice a pattern here. I said name, but we could also say choose. All of these involve choose, name, choose. You get to make the decision instead of leaving the decision up to a judge who you likely have never met and who likely doesn't know your family situation. So the reason to make a will is choices. You get to control and you get to lay out the rules for what should happen to your assets and estate after you're gone. And really making an estate plan is the ultimate gift to your family, because you're laying out a roadmap for them and removing the burden from them of trying to figure out all of this after you're gone. Because when I see cases come in where there's no will at all, that's often what I hear. Confusion, chaos, and unfortunately sometimes disagreement over what to do, because no one laid it out what should happen, a roadmap for their estate. So these are the 3 things a will can do. I hope this is helpful to you. As always, this series is designed to educate and inform in order to empower you to take control of your own estate planning. And if you're thinking about doing some estate planning, hopefully by watching this video you can be better informed when you go to meet with your attorney to put your estate plan in place. If this video has been helpful to you, please consider giving it a like so that others can see and benefit from this information as well. Thanks for watching, and we'll see you next time.